All right, Ms. Rivers, can you hear us from here in 8D?
Yes, I can.
Great, then we will get started. This is case 23 SC 186557, State versus Destiny Brown Moore. This is part 2 of the immunity hearing. Part 1 we had in late June, and we ran out of time. I think we received all the evidence that Ms. Gordon wanted to present, but I'll confirm that in a minute. Ms. Brown Moore is here. How are you, ma'am?
I'm okay. How are you?
I'm well. Good to see you again. And Ms. Brown Moore's lawyer, Ms. Gordon, is here, assisted by Ms. Wood. Mr. Abate is here for the state. Ms. Gordon, am I correct? Did you present all the evidence you intended to present, or were there other witnesses you were going to call?
I do have 2 additional witnesses that I'll call today, Judge. They should not be lengthy.
Okay.
And before we get started, I do just want to put on the record for my client's peace of mind, and just for the record, there are a lot of media cameras in here today. I just want to confirm that those are not here for us and they are not rolling for this hearing.
Sure. I'm sorry, Ms. Brown Moore. I should have explained that. I explained it to the defendants who were here this morning. I'm presiding this week, which means other business that's not assigned to me can walk through the door. And today, through the door could come an indictment that a few folks have been curious about. And so the media is here for that. They're not here for me. They're not here for you. And in fact, they've all been instructed, all the reporters and camera people have been instructed not to record anything, audio or video, unless it is indictment presentment time. And a few people will walk through the door with a stack of papers, and we'll pause what we're doing with your hearing, if it happens then, and handle that, and then we'll pick your hearing back up. Okay. But it's a public courtroom, so anyone in here, of course, is free to listen and watch as to what's going on, but it's not being recorded. It's being live streamed, so people outside the courtroom can watch it as well if they're interested in following this. I have a meeting at 4, so hopefully your 2 witnesses plus what Mr. Abate wants to present will be done by 4. It's kind of a non-movable meeting. I'll come back here if there are indictments that need to be presented, but otherwise I need to be at that meeting in the other building. So without further ado, then Ms. Gordon, if you want to call your next witness.
Judge, I'm sorry to interrupt just real fast. We had presented some evidence previously during the June hearing. I don't know if you had that with you.
I think so. This is everything from the previous hearing. I've got a bunch of notes and then state's exhibits. It's some photographs, the knife on the ground, the pink and purple gun. So there are a bunch of photos, but there are only 4, I guess, because the exhibit numbers go through 22. I kept 4. I don't know if those were the 4 that you asked me to keep, or if Ms. Rivers, I'm confident Ms. Rivers would have the others if you tendered them all. She may have been here in person for part 1 of the hearing.
She wasn't, but I think I only tendered the ones you had. I just wanted to make sure that you have them. You got it.
I have that there were just 4 tendered as well, Judge.
Great. I have 4. I have, so the record is extra clear. I have State's Exhibit 22, which is an Acura that looks like it's been rear-ended. State's Exhibit 2, which I think is the crime scene. There's a bunch of yellow tape. 21 is that gun I mentioned, and then 18 is the knife open on the ground with an evidence placard next to it. That's what I've got.
Yes, Judge.
Okay. And when you say you tendered it, that would have been through, I guess, Ms. Brown Moore during your cross-examination.
Yes, sir.
So I think that's the only witness we've had so far.
That is correct.
Yes.
Okay. All right. Great. Anything else?
Here. You can cross states out.
Judge, do you have, or do you know where the defense exhibit stickers are?
With you, you're the defense attorney.
I do not have stickers, Judge. I have state's exhibit stickers that Mr. Abate just gave me that I can.
You could look in the drawers up here to see if Ms. Rivers had any spares. She usually rolls out with a box of supplies, and that's where they'd be. But if you want to look in there,
Excuse me, Judge, there are some in the side drawer in a yellow envelope.
Side drawer, the only side drawers are right there.
To the right, the top right drawer,
Yeah, on the top drawer or second drawer?
the top drawer to the right of me where I would sit.
Okay,
There's a yellow envelope. There should be some defendants exhibit stickers in there.
that big envelope there. Mine, all right.
Thank you, Mr.
Yep, she owes you. She took a whole stack of them.
Is the court ready for the
I
defense's next
am,
witness?
please, yes.
And Judge, this is the witness, if you'll recall, that is going to testify via Zoom.
Oh,
And she is signed, she was signed, oh, she is signed in. And the defense would call at this time Jessica Brown.
all right.
So Miss Brown, if you can hear me, yep, there you go, video and audio. Can you hear me?
Yes, I can hear you.
Great, we can hear you too.
So we need to swear Ms. Brown in. Do you mind doing that, Sarge?
Will you raise your right hand? You solemnly swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but truth, so help you God?
I swear it.
You can take your hand down, state your first and last name with the spelling of both names, please.
Jessica Brown, JESSICA BROWN.
And Miss Brown, what is your relationship to Destiny Brown Moore?
My sister,
And how long have you known Destiny?
my whole life.
Are you her older or her younger sister?
Oh, older sister,
Okay. How many years separate the two of you?
1.
All right. And Miss Brown, where do you live?
I live in New York.
And is that why you couldn't be here in Georgia today?
Correct.
Okay. Miss Brown, this may be an obvious question, but do you love your sister Destiny?
Yes, I do.
Do you love her enough to lie for her in a court of law?
No, I wouldn't lie for her.
Okay. Do you recall speaking with Destiny on the phone in the early morning hours of August 29th, 2020?
Yes,
And do you remember approximately what time that call was?
maybe 3, 4 in the morning.
Did she call you or did you call her?
She called me.
Okay. And you answered that call?
Yes.
What did Destiny tell you during that phone call?
And I'm gonna object to hearsay.
Your Honor, Destiny already testified here in this court. Mr. Abate had a very full chance to cross-examine her.
So it's an out-of-court statement being, I assume, offered to prove the truth of the matter asserted, or is it being offered for some other reason?
Judge, it is being offered. Mr. Abate attempted on his cross-examination to impeach Destiny's truthfulness. And so this is, give me 1 second, Judge.
Sure. So meant to be a little more real time than what you're doing right now.
I understand. Sorry, Judge. Judge, essentially, this testimony is to refute the allegation of lack of truthfulness that Mr. Abate, I anticipate Mr. Abate will make during his argument, and that he crossed Destiny on while she was on the stand at our last hearing.
So isn't the best way to get evidence of what Ms. Brown, your client, said to Ms. Brown in New York, what Ms. Brown, your client, says she said, which you've done because you examined Destiny Brown? It's not.
I think that what this is getting at, Judge, is that Mr. Abate is going to argue that there was a fabrication by Ms. Brown Moore. And this is a prior consistent statement. That's what I was looking for, Judge. I
Okay.
apologize. This is to go to a prior consistent statement made by Ms. Brown Moore close in time to the incident date.
Okay, I'll allow Jessica Brown to answer your question. Why don't you ask it again?
Thank you,
So
Judge.
she is brought back to where we were.
I will. Ms. Brown, during that phone call in the early morning hours of August 29th of 2020, what did Destiny tell you?
Okay, she called me, was very distraught, high pitched voice, and you could tell panicky. And basically she just told me that she thinks that she killed someone. And I was like, what? Slow down, like what are you talking about? And she said that she was leaving out of a club or something like that, and then she was in a car talking to a gentleman, and he got rough with her. He told her basically that he would rape her. I think she mentioned that he said, you're gonna give me this pussy, and he was
Judge,
choking her.
Stop for a second.
I'm gonna object again. This is double hearsay because it's what Destiny told her that Mr. Hundal told Miss Destiny. So I would object to double hearsay at this point.
Now we've got double hearsay objection. Do you want to limit Jessica Brown to describing what her sister told her, not about what other people said?
Yes. So Ms. Brown, without telling us anything that anyone else said, so without saying what this man may have said to Destiny, just tell us what Destiny told you about what happened, what he did, what she did, etc.
Okay. She said being choked, and then she reached for a firearm, and she shot. Can I say he got out the car and got into his vehicle, and then as he was driving away, he swerved, and I believe he hit the guardrail.
Did she give you any other details about what he did?
From what I remember, I just remember she said about the gun that she had to end up shooting.
And did she tell you why she shot?
What, he was choking her.
And talk again, you mentioned this a little bit before, but talk again a little bit about Destiny's demeanor, how she sounded to you during that conversation.
She was very frantic. She was scared. She was very high pitched voice. It took me, I had to calm her down because at first I couldn't even understand what she was saying.
Did you give her any advice at that time?
I told her that she should calm down and then think about what she should do next. Because I I felt she was not in the wrong. So if she was to reach out to the authorities, she would be fine.
And so you did talk to her about reaching out to the authorities.
Yes.
Did you reach out to any authorities at that time?
I did not.
Why not?
Well, because I'm all the way in New York, number one. And I didn't know that was something I could actually do.
Okay. Give me just a moment. That's all I have, Ms. Brown. Mr. Abate might have some questions for you.
Ms. Brown, before Mr. Abate asks you any questions, I've got a couple questions. I'm Judge McBurney. Nice to meet you. Where are you in New York?
I'm in Manhattan, New York.
Okay. I thought I heard you say in describing what your sister told you, that she said he was choking me and then I shot him and then he got out of my car, meaning your sister's car. Is that what you recall her telling you? And then he got in his own car and drove away and crashed.
Yes.
So she described whoever this guy was as being in her car, choking her.
In the car. Right.
Okay. Did your sister tell you at all about how she was able to get a gun, where the gun was, or just, I had a gun and I shot him because he was choking me?
Either the dashboard or the thing up top in the car. We
Saying either, so it sounds like you don't remember. I'm not asking you to guess. I just want to know what you remember.
She reached, it was in the car somewhere.
Okay. Got it. Thank you. Mr. Abate.
Thank you, Judge. Good afternoon, Ms. Brown.
Well,
You said that you're a year older than your sister Destiny,
correct.
and can you tell the court what do you do for a living?
I'm a sales advisor.
You're a sales advisor?
Yeah.
Okay. And when did you move to New York?
When did I move to New York?
Yes.
I'm from New York.
Okay. So did you grow up with your sister? Yes or no?
She's from New York as well.
Okay. And how long, you said you've known her whole life. How long did you both live in New York? When did she part ways?
She left when she got pregnant with a daughter. So,
Okay. Okay. Now, I want to take you to August 29th of 2020. And you said that your sister called you, you said around 3 or 4?
it was early in the morning for sure.
Okay. And during that conversation, it sounds like you said that she just told you the man was choking her and she shot him while they were inside of her car, correct?
Correct.
And it sounds like from what you said on direct, she didn't mention anything to you about a knife being involved, correct?
I don't remember anything about a knife, no.
Okay. And did she tell you when you were speaking with her where she was when she, I guess, made the call to you?
The street,
Okay. Do you guys have any other sisters, Ms. Brown?
yes,
Okay. And can you tell me is it her or their names?
Valerie Moore and Portia Moore.
Okay. And do both Valerie and Miss Portia live here in Georgia or the city of Atlanta?
Yes, they live in Georgia.
Okay. And would you agree that Destiny had access to both those sisters who live in town, correct?
Yes,
Okay. In fact, she was living with one of them close in time to when this incident occurred, correct?
Yes,
Okay. And after your sister told you that she believes she may have killed someone, did you call either Valerie or Portia and talk to them in regards to what Ms. Moore told you?
I did not.
You did not.
No.
You would agree that your sister telling you that she may have just killed someone is a pretty insane thing to hear in the middle of the night, correct?
Yes,
And this incident happened back in August of 2020. We're now in August of 2023. Can you tell the court how many times have you spoken to your sister about this incident in the last 3 years?
Which sister?
Excuse me, how many times have you spoken to the defendant?
we only spoke about this once.
So after August 29th of 2020, you and your sister, the defendant, Miss Destiny Brown Moore, never spoke about this incident again.
I'm in New York. We weren't gonna like have phone conversations about this. So no, we only
Okay.
spoke about it once.
And back during that time, and I guess currently, how often would you say that you spoke to your sister?
I've spoken to her a few times often.
Okay, well, it's been 3 years. So when you say a few times, we talking once a year, twice a year, once a week?
Maybe like once a month.
Okay. So in the numerous conversations that you had with your sister after she called you in the middle of the night and told you she believed she killed someone, it's your testimony that you guys never spoke about it again.
We never spoke about it again.
Okay. And you never spoke to either one of your other sisters about what Destiny had told you, correct?
Yeah, no.
Okay. Judge, I don't have any further questions.
All right. Ms. Gordon, any redirect of Jessica Brown?
No, Judge.
All right. Jessica Brown, thank you for patching in from Manhattan. You are free to go. Appreciate your time.
Thank you, Judge.
All right, Ms. Gordon, next witness.
That's all I have, Judge.
Okay.
Chris.
So your presentation consists I'm looking through my notes from before. Your client testified extensively back in June, and then we've heard from Jessica Brown, your client's sister, older by 1 year. All right.
Correct.
Mr. Abate.
Judge, state would call Detective Thorpe very briefly.
You solemnly swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Please state. Position yourself up to the mic. State your first and last name with the spelling of both names, please.
Detective J. Thorpe Jr., City of Atlanta Police Department, Homicide Unit, THORPE.
And good afternoon, Detective Thorpe.
Good afternoon, sir.
Can you tell the court how long have you worked with the City of Atlanta Police Department?
29 years and 8 months.
And of those 29 years, can you tell the court how long you have been assigned to the homicide unit with the City of Atlanta Police Department?
20 years.
And can you tell the court, did you get involved or were you assigned as the lead detective for a case that occurred back in on August 29th of 2020 involving the defendant, Destiny Brown Moore?
Yes, I did.
Okay, and can you tell the court where, I guess, was the scene of the incident, or where did the incident occur?
The scene happened at 210 Auburn Avenue, City of Atlanta, Fulton County, State of Georgia. The decedent had crashed his vehicle into the retaining parking deck wall of the parking deck.
And were you dispatched to the scene, or were members of the Atlanta Police Department dispatched to the scene due to a 911 phone call around 6:20 in the morning?
Yes, sir.
And as a result of you being dispatched and assigned as a lead detective, can you tell the court kind of what your first steps were when you arrived to the Auburn Avenue area?
Yes, sir. Upon arrival, I was met by the major crime response team. They were the first units on, they were the second units on the scene next to the Zone 5 morning watch patrol officers.
Mhm.
At the time, I got a quick debriefing of what they responded to, what information they had gathered. The remaining day watch homicide detectives arrived a couple of hours later. I started processing with the crime scene text and going over to try to get the victim positively identified.
And I want to show you what's been previously marked as state exhibits 5 through 15. Take a minute to peruse through those.
Yes, sir.
And Detective Thorpe, do you recognize state exhibits 5 through 15?
Yes, sir.
And can you tell the court, how do you recognize them and what are they?
Those are the crime scene photos of the incident at 210 Auburn Avenue.
And the state exhibits 5 through 15 fairly and accurately depict how the crime scene looked when you arrived back on August 29th of 2020 around 6:30 in the morning.
Yes, sir.
Your Honor, this time the state would tender what's been marked as state exhibits 5 through 15 into evidence.
Any objection, Ms. Gordon, to states 5 through 15?
No objection.
They're admitted. Thank you.
Now, Detective Thorpe, when you said you've been in the homicide unit the last 20 years, but you worked with the City of Atlanta Police Department for the last 29 and a few months.
Yes, sir.
And in that time, working in various units, but specifically the homicide unit, are you trained in how firearms work and how to use them?
Yes, sir.
And can you tell the court when a firearm, a pistol is fired, what happens?
If it's a revolver, the shell cases do not get ejected from the cylinder of the revolver, but on a semi-automatic pistol, the rounds are ejected to the right.
And that's for most semi-automatic pistols, correct?
Correct.
And when you arrived on a scene, you said you, I guess, walked through and helped process the scene. Were any shell casings located on the Auburn Avenue scene where Mr. Hundahl was found deceased in his car?
Yes, sir.
Can you tell the court about where the court has the crime scene photos 5 to 15, but from your recollection, as he's looking through them, generally in what area did you find a crime scene, or excuse me, shell casings?
The shell cases was found in the street of Auburn Avenue.
And to your recollection, were there several shell casings that were found and marked by individual placards by the crime scene techs while you were present?
Yes, they were.
Now, were any shell casings from your recollection found inside of Mr. Hundal's vehicle?
No, sir.
Okay, and when you arrived on scene, was Miss Destiny Brown Moore, did she remain on scene?
No, sir.
Okay, and when you arrived at that point, other than having a deceased Mr. Hundal in his vehicle, did you have any, I guess, leads as it relates to how Mr. Hundal had been shot at that time?
No, sir.
Okay. Now, can you tell the court, as you continued your investigation, how did you, or what furthered your investigation as identifying Miss Destiny Brown Moore as a suspect?
Yes. About 2 years later, Zone 5 Morning Watch received a call from the DeKalb County Police Department, stated that they had a subject that just confessed to a homicide that happened on Auburn Avenue 2 years ago. At that time, the homicide supervisor, Sergeant Smith, was able to ascertain that that was the case that I was currently working. At that time, Sergeant Smith sent out an email just as I was coming into the office, and he briefed me on what he received. At that time, I was able to contact the DeKalb County Police Department and found out where they got the information from. And it was information provided by Officer Williams that he recorded on his body camera.
Okay, and through your, I guess, investigation and speaking with Officer Williams, were you able to get a copy of that body cam?
Yes, sir.
Okay, and after receiving the body cam footage from Officer Williams, did you, I guess, attempt to locate Miss Destiny Brown Moore?
Yes, I did.
Okay, and can you tell the court where or what you did first in an attempt to locate Miss Brown Moore?
I got the individual identified through Officer Williams, who advised me of their relationship. At that time, I ran her through a couple of law enforcement databases and found the last known address of her out in East Point, Georgia. Myself and Detective Benton, also of the homicide unit, went out to the address in East Point to try and make contact and speak with Miss Destiny Brown Moore. At that time, we only made contact with her sister.
Okay, and do you recall what her sister's name was?
Not on the top of my head, I'm sorry.
But based on your recollection of your investigation, one of her sisters lived at the East Point address.
Correct.
And when you got to the East Point address, did you request to see Miss Brown Moore?
Yes, I did.
And were you able to successfully speak to her at that location?
No, sir. Her sister advised me that she does not live there, that she lived there for a minute, but she doesn't live there anymore. And I gave her my business contact information and advised her when next time she speaks to her sister, have her sister get in contact with me.
Okay. And during the time that you were at the East Point address looking for Miss Brown Moore, were you able to get any information as it relates to what happened on August 29th of 2020?
No, I did not.
Okay. And did you provide Miss Brown Moore's sister your contact information to provide to Miss Brown Moore if she was in contact with her?
Yes, sir.
Okay. Now, as a result of that visit to her sister's house in East Point, Georgia, here in Fulton County, can you tell the court what happened next on May 19th, that same day?
Later on, the evening of May 19th, I received a phone call, and it was Miss Destiny Brown Moore on the other end. I went ahead and recorded our conversation, based that she was a person of interest in this homicide investigation. I explained to her what the situation was about and how I came about to going to talk to her. She said that she has no idea what I was talking about.
And did you explain to her during that phone conversation that you had received a body cam video of her making reference to and admitting to shooting the victim in this case, Mr. Hundal, and alleged self-defense.
Yes, sir.
Okay, and you said that phone call was audio recorded?
Yes, sir.
That same day, later, did she call you a second time in regards to this conversation that you guys were having at this point?
Yes, sir.
And can you tell the court during that second phone conversation, was that recorded?
Yes, sir.
And can you tell the court what that conversation consisted of?
So there was on the same day, there was a second call. Ms. Brownmore called you back.
Yes, Your Honor. And again, the conversation was dealing with the body worn camera footage of her conversation with Officer Williams. And again, her saying she has no recollection of what I was talking about.
And do you recall her saying back that that would be impossible?
Yes.
Okay. I want to show you what's been previously marked State's Exhibit 17. We'll take a look at that. Tell me if you recognize it.
Yes, sir.
And can you tell the court what is State's Exhibit 17?
This is the CD recording of download of the auto recording of myself and Ms. Destiny Brown Moore.
Okay. And does State's Exhibit 17 contain both phone calls that were recorded on May 19th, 2020?
Yes, it does, sir.
Do the phone conversations that the copy of the phone conversations that can be found on State's Exhibit 17, that they fairly accurately depict the actual conversation that you had with Ms. Destiny Moore or Brown Moore on May 19th of 2020?
Yes, they do, sir. Yes, they do.
2022.
Yes, sir.
Your Honor, this time the state would tender what's remarked as State's Exhibit 17 into evidence.
No objection.
Admitted.
Now, after your conversations with Ms. Destiny Brown Moore, did your investigation continue?
Oh, yes, it did.
And through your investigation, were you able to determine the phone number that Ms. Destiny Brown Moore had at the time of the shooting on August 29th of 2020?
Yes, I did.
And can you tell the court, after requesting and receiving her phone records and her cell site location data, what that information told you?
The information showed that Ms. Destiny Brown Moore was in the area of the homicide, I think about 2 or 3 hours prior to the incident. And the cell phones records also indicated that she was leaving the scene right about the time the homicide had happened.
Okay, and when you say right about the time the homicide had happened, is that right about the time that the 911 phone call was received reporting the incident?
Yes, sir.
Now, did you also get information as well as a photograph of a 9mm firearm owned by the defendant at that time?
Yes, I did, sir.
And can you tell the court where the shell casings that were located and collected at the scene here or at Auburn Avenue, were they also 9mm shell casings?
Yes, they were.
Okay. Now, the gun that was depicted in the photographs, and I can't remember which State's Exhibit it is, that we previously omitted, but
21.
21. Were you able to locate that firearm?
No, sir.
Okay. And in your investigation, or were you able to determine what type or and color of vehicle the defendant was driving back on August 29th of 2020?
Yes, sir.
Okay. And can you tell the court, do you recall if it was a sedan, an SUV, and the color of it?
Yes, sir. It was a sedan, white in color, and it was Acura, I believe it was.
And were you provided a photograph of that vehicle that she was driving back on August 29th of 2020?
Yes, I was.
Okay. And based on all of that information that you had developed through your investigation, did you take out arrest warrant for Ms. Destiny Brown Moore?
Yes, I did.
And can you tell the court what those warrants were for?
It was for murder, felony murder, aggravated assault, and false statements.
Okay. And after those warrants were sworn out in front of a magistrate court judge, was Ms. Brown Moore arrested back on December, I believe it was 22nd 22nd of 2022.
Yes, she was.
Excuse me, December 20th of 2022. And after her arrest, did you have an opportunity to speak with her, interview her?
Yes, I did.
And at this point or at this time, where did this interview occur?
It happened at Public Safety Headquarters in the state of Atlanta, Fulton County, state of Georgia. The address is 226 Peachtree Street, Southwest.
And at this time, was Ms. Brown-Moore in custody?
Yes, she was.
And prior to speaking with Ms. Brown-Moore, did you Mirandize her and advise of her right to silence and her right to counsel at that time?
Yes, I did.
And after advising her of her Miranda rights, did she agree to have a conversation or speak with you?
Yes, she did.
And in the room that you were in down at APD headquarters, is it equipped with audio and video surveillance and recorders?
Yes, it was.
And I want to show you what's been marked as State Exhibit 18.
Yes, sir.
Do you recognize the jump drivers inside of State Exhibit 18?
Yes, sir.
And can you tell the court what is State Exhibit 18?
It's going to be the downloaded interview from December 20th, 2022 of myself and Ms. Destiny Brown-Moore.
And prior to this hearing, have you had an opportunity to review in part and in whole that interview?
Yes, I was.
And did that, I guess, the copy of the interview that occurred on December 20th, 22nd, is it fairly and accurately depicted in State's Exhibit 18?
Yes, it is.
Your Honor, this time the State Lieutenant was marked as State Exhibit 18 into evidence.
No objection.
States 18 is admitted.
Now, Detective Thorpe, briefly, I just want to talk about the interview that you had with Ms. Brown-Moore on December 20th, 2022. During that time, did you reference or speak to her about the video that you had received from Officer Williams, the DeKalb officer who Ms. Brown-Moore previously was in a relationship with?
Yes, I did.
And after telling her about what's depicted in that video that you received, what was her response?
She said she does not recall. She denied having any information. And she referenced that she probably was high during that time with Adderall and some other drugs.
Did she also reference that it again was impossible and that she had never had a conversation with anyone in regards to what happened on August 29th of 2020?
Objection, Your Honor, leading.
I'll rephrase, Judge.
Okay.
During that interview, did she acknowledge knowing anything about what happened at Auburn Avenue on August 29th of 2020?
She denied any knowledge of what happened that night.
And during that conversation, did she provide you with any information in regards to telling anyone about anything she may or may not have known about what happened on August 29th of 2020?
She advised me she did not tell anybody about what happened that night.
Did she talk to you or did you ask her about her ownership of a pistol back during that time in August of 2020?
Yes, I did.
And can you tell the court, what did she tell you about her ownership of any firearms back then?
She stated that she owned, it was probably a 38 and she already got rid of it.
And during that conversation, did you ask her to describe anything that she could recall about the gun that she owned back on August 29th, 2020?
Yes, I did.
And was she able to give you any description about the gun she owned?
I believe she did.
Okay. And do you recall if she was able to tell you in State Exhibit 21 that the judge showed you, is that gun pretty colorful and bright?
Yes, sir.
And at any point during that conversation, did she describe to you owning a gun that looked like it had been, spray painted with a bunch of colorful glow in the dark paint?
Yes.
Okay. Now,
I'll make sure I follow that. So Ms. Brown-Moore told you, I think I might have a gun back in August of 2020. If I did, it was a 38 and I got rid of it.
Yes, sir.
She described it as pink and purple and all that?
Yes, sir.
Oh, okay. So the description she gave of the 38 she didn't have anymore was consistent with what you see in the picture?
The 9mm pistol. yes,
Okay.
sir.
And was she able to tell you how she got rid of it or how she was no longer in possession of the firearm?
I believe she said it was some to the degree that it was probably still in the car that she sold, and she doesn't know where that car went.
Okay. That leads me to my next question. When she was arrested back in December of 2022, was she still, I guess, in possession or ownership of the white Acura that she had previously been in possession of?
No, sir.
Okay. During that interview, as it continued, was she ever able to give you, or did she ever give you any information in regards to what happened that night in August of 2020?
She gave no information.
And at any point during the interview, did she indicate to you that she had been physically or assaulted?
No, sir.
Did she ever indicate to you that there was any attempt to sexually assault her by anyone during that time on August 29th of 2020 or ever?
No, sir. She did not.
During your interview with Ms. Brown-Moore, did she ever once mention that she had been in any sort of struggle that involved a knife, a gun, and being held and choked in a vehicle?
No, sir.
And at any point during that interview, did she ever indicate that she fired a weapon back on August 29th of 2020?
No, she did not.
And was the interview with Ms. Brown-Moore relatively short?
Yes, it was.
Can you tell the court why?
Because she was basically saying she does not recall. She don't know what I was talking about. Pretty much just denied the whole situation ever happened.
I just have 2 or 3 more questions, but I want to take you back to May 19th of 2022 when you spoke to Ms. Brown-Moore over the phone. During that call, can you describe to the court kind of the demeanor or the tone that Ms. Brown-Moore took during both of those phone conversations?
Like a better way to describe it, playful. Wasn't taking it serious, what I was asking her about, and just dancing around every question I was asking her.
Okay. And for lack of better words, at points during those phone calls, she actually attempted to kind of flirt with you.
Yes, sir. She called by my first name. I don't allow no one to call me by my first name.
She talked about seeing you at a club or being at a club that, you know, she had saw and y'all had a exchange.
Yes, sir. I don't go clubbing. Never have.
Thank you very much, Detective Allen, for the questions at this time.
Yes, sir.
Ms. Gordon, do you have questions for Detective Thorpe?
I do, Judge. Thank you. Good afternoon, Detective Thorpe.
Good afternoon, ma'am.
A few questions for you.
Yes, ma'am.
Your investigation revealed that over $1,300 in cash was found on Mr. Hudnall's person. Is that correct?
Yes, sir. Yeah, I'm sorry. Yes, ma'am. I'm sorry.
And another, I think about $40 in cash was found in plain view on the floorboard of his car.
Yes, ma'am.
An Apple iPhone was also found in plain view on the floorboard of his car.
Yes, ma'am.
He was also wearing some jewelry, I believe a couple of chains with pendants and a watch.
Yes, ma'am.
As far as you know, over the course of your investigation, nothing was stolen from Mr. Hudnall's person or his vehicle that night.
No, ma'am.
There was blood spatter found on the exterior of Mr. Hudnall's vehicle. Is that correct?
If I recall, yes, ma'am.
And that was on the driver's side of the car.
Yes, ma'am.
And on that same side of the car, the driver's side, the back passenger window was shattered. Is that correct?
I can't recall. I think there was a defect to the window. I don't think it was shattered. I can't
Okay.
recall.
I'm actually, if I may approach Judge,
You may.
I can hand you what have been marked as defense exhibits 1 through 8, if you could just look through those for a moment.
Yes, ma'am. Yes, ma'am.
Do you recognize those photos?
Yes, ma'am.
What are they?
Those are the crime scene photos of that night.
Okay, and do those fairly inaccurately depict the crime scene from that night and the evidence that was found that night?
Yes, ma'am.
Have those been changed or altered in any manner?
No, ma'am.
Okay.
Just in black and white. That's all.
Right, defense would move to tender exhibits 1 through 8 into evidence at this time.
Mr. Abate, any objection?
I have no objection. Can I just look at them? Just
Sure.
to see what's going on?
And I'm assuming, Ms. Gordon, these are exclusive to there are lots of crime scene photos. It could be 100, but your 1 through 8 don't overlap in any way with the state's photos. These are different pictures.
That's correct. Judge.
All crime scene photos probably taken by the same technician, but a different subset of the total universe.
Yes.
Okay,
No.
great. Admitted. Do you need the detective to hold on to them for your questions?
Please, thank
Okay.
you. That's right. Detective, could you tell the court what's in photograph number 1?
Okay. Photograph number 1 is going to be the Ritz-Carlton door card to his hotel room that he rented that weekend with his friends. And the cash that was taken out of his pockets, and also a claim ticket for the Chevy Malibu he was driving, which in turn turned out to be his friend's car.
Okay, what's in number 2?
Number 2 gonna be the crumbled up dollar bills that was on the passenger side floorboard.
Number 3?
It's going to be a further away shot of everything inside the passenger floorboard, front seat passenger floorboard.
And that includes cash crumpled up, correct?
Correct. I'm sorry. Yes.
Okay. Number 4?
Number 4 is going to be the close up of the cash that was taken out of his pockets.
Number 5?
Again, the continuation of the cash taken out of his pockets.
Number 6?
The remaining cash taken out of his pockets.
Number 7?
We're holding up, about to do the count for the cash. That's my hand holding the cash.
Holding more cash.
Yes,
And
ma'am.
number 8?
That is going to be the driver's side of his vehicle. And the one you indicated, it was not blown out, it was shattered, that's all. Because he had heavy tin on it, so the glass didn't fall out.
Can I
Got
see
it.
the 8? Thank you.
Yes, sir.
Did a crime scene tech or you ever identify a defect to the window consistent with a bullet hitting the window? It's clearly shattered, but in place like car windows do. I just can't tell from the black and white picture if in the middle somewhere there's a,
Yeah, it was, I believe it was in the upper right portion of the window.
okay. Thank you.
So just to be clear for the
I'm
record.
sorry, I'm sorry.
Sorry.
Right, yeah, I'm sorry.
Upper left where it's white,
Yeah.
like a finer shattering.
Yes, sir.
Okay.
The door frame, I'm sorry, the window frame.
So just so we're clear, there was a defect from a bullet to the upper left portion of that back passenger driver's side window.
Yes, ma'am.
And from your investigation, the window shattered as a result of that defect?
Yes, ma'am.
Okay. Now, that defect and that shattered window, well, let me ask a different question. You mentioned the Ritz-Carlton card that was pictured, I believe, in exhibit number 1.
Yes, ma'am.
Did that indicate to you that Mr. Hudnall had been staying at the Ritz-Carlton that night?
Yes, ma'am.
And did you find any other evidence that he had been staying at the Ritz-Carlton that night?
It was going to be a receipt, parking receipt for the parking deck for the Ritz-Carlton.
All right. And we don't have this in pictures, but Mr. Hudnall was wearing all white when he was located, correct?
Correct. And that's also his nickname.
All White?
Yes, sir. He always wearing all white,
Oh, his nickname is White or his nickname is All White?
all white.
Okay.
Now, this case essentially was cold from 2020 when you arrived at the scene until 2022 when you got that call from DKPD, correct?
Correct.
Okay. And so there were no other witnesses to this incident, is that right?
Only one we got was after I cleared the crime scene back at the office, trying to do a victimology on the situation. I received an anonymous phone call and the person stated when they was leaving the club, walking up Auburn Avenue, he saw a dark colored vehicle parked next against the curve and a white vehicle double parked next to that vehicle. He said he could not tell who was in the vehicle, what race, whatever. And he continued to walk up. He said, just as he passed the vehicles, that's when he heard the shots fired.
Okay.
And he said he took off running.
So
And
that witness wasn't able to tell you, wasn't able to identify the people,
no,
correct? And wasn't able to tell you what, if anything, was going on between those two people prior to the shots being heard.
correct. He just said I was walking up the sidewalk, heading to my car to go home.
And there were no other witnesses that you were able to locate.
A couple people there, they said, they saw the car just crash. That was it.
Okay. Now, you talked a little bit on direct about the actual body cam video that you received from Officer Jeffrey Williams from DeKalb County Police Department.
Yes, ma'am.
And you watched that video,
Yes, ma'am.
and you're not really able to see much when you view it, right?
Yes, ma'am.
Okay, so mainly when you watch that video, you're listening for the
Yes.
audio.
Yes,
And what you're hearing when you watch that video is the conversation had between Ms. Brown Moore and Mr. Williams.
right. I go ahead and clarify. He was talking to her on his cell phone and he had his cell phone on speaker.
Right. And the conversation actually doesn't start at the very beginning. Is that right?
Correct.
So when you first start playing that video, you start somewhere amidst a conversation that is already happening.
Correct.
Okay. And during that conversation, when you listen to it, Destiny told Officer Williams that when this incident happened, that she was lying on her back in her car,
Yes.
right? She told him that she was struggling with a man who was on top of her.
Yes, ma'am.
She told him that he was trying to get her knife from her.
Yes, ma'am.
She told him that while he was focused on that knife, that's when she was able to reach for and get her gun.
Yes, ma'am.
And she told him that she shot him from inside her car, or
Yes.
shot at him from inside her car.
Yes, ma'am.
Okay. And over the course of your investigation, you've found or received no evidence to contradict that account that Destiny told to Officer Williams.
Basically, that from the initial date of the incident, the shell casings were on the outside, on the city street itself. If she had fired, discharged her weapon that multiple times inside the vehicle, the shell casings would have been inside her vehicle, not on the sidewalk. I mean, not on the sidewalk, but in the city street.
Okay,
So that was the contradictory started at right there.
you said that's where it started at. Is there more?
No, when she basically stated that he was laying on top of her inside of her car and that she shot him inside of her car.
Mhm.
Like I said, the shell casings were outside in the city street. That's
Got
what
it.
I'm talking about right there.
So let's talk a little bit more about that. I'm going to try to demonstrate, but let me know if this is ineffective and I'll try
Okay.
something new. If I'm sitting in a car, I'm sitting in the driver's seat of a car, right? You
Mhm.
stated on direct that the shell casings from a semi-automatic weapon will eject to the right,
Correct.
right?
Yes, ma'am.
So if I'm sitting in the driver's seat of a car with the window to my left,
Hmm.
right in front of me, I've got a steering wheel and a dashboard and a windshield.
Yes, ma'am.
right? If I turn to my left, if there's someone in my car from the driver's side door or window, and I turn to my left with that weapon and fire it, there are several surfaces here that a shell casing could hit or ricochet off of. Would you agree with that?
Yes, ma'am.
Okay, and so it's possible So if I, in the driver's seat of that car, fire that weapon, the shell casing ejects to the right, it's possible that it ricochets off. And if the door or window is open, it ends up on the street outside that vehicle.
Correct, but based on what she was saying, that she was pinned down inside the vehicle on her back. So once again, if she's shooting inside the vehicle, she's on her back looking up, then the shell casing would have been inside the vehicle. And I found this way outside.
Just one moment. That's all I have. Thank you, Detective.
Yes, ma'am.
Ms. Gordon, I'm curious to know, and this isn't necessarily the right witness for it to come in, and so you can object, and I'll probably sustain the objection to my own question. Where the victim was hit, and if a medical examiner said this was an entrance wound, this was an exit wound. And I suspect that Investigator Thorpe knows some of that because he's read someone else's report, but he wouldn't have been the author of that report. He would have, as part of his investigation, learned about it. And we're in an immunity hearing, we're not at trial, so we're somewhere in between. But before I ask that question, I wanted to share it with you so you could say, you know what, if the state wants that, the state needs to call the medical examiner.
Can you give me just a moment, Judge?
Sure.
I did.
Judge, I would object to that as hearsay. I think if it's going to come in, it needs to come in through the ME.
Okay. I mean, I can't meaningfully explore it with this witness, and there could be aspects of, well, you know, you've heard medical examiners. I think this was the entrance wound, but you know what? It's like 60-40. Maybe the entrance wound was there. So, okay. Thank you. Mr. Abate, do you have anything else for Detective Thorpe?
Briefly, Judge. And for the record and for the court, I had the medical examiner here last time. She was unable to come today, but just for your edification.
Okay.
I figured that we've already delayed it since June. I wasn't going to delay it further.
Okay.
Detective Thorpe, would you agree that there were at least 4 shell casings that were located in the middle of a street in the city of Atlanta and not in anyone's vehicle?
Yes, sir.
Okay. And during your processing or assisting in the processing of the crime scene, was a knife located?
Yes, sir.
Okay. And can you tell the court, in your recollection, and I have a photograph of it if you can, where the knife was found?
Yes, Mr. Bott. The knife was found outside the decedent's vehicle at his left rear tire.
So that, I don't know where that picture went. Oh, it's right here.
Okay.
Hold on. Okay, so that puts that in context. I'm giving you State's Exhibit 18. Detectives already in evidence came in June. So that vehicle is the vehicle in which the deceased was found. The one that we have pictures of, it's crashed into that brick wall.
Yes, Your Honor.
Okay.
Okay. Now, so the knife was found quite a bit of distance from where the shell casings were located from where the gunshots occurred.
Correct. Basically across the street.
Okay. Not found in any vehicle where any struggle had occurred, correct?
No, sir.
Okay. And lastly, I want to show you State's Exhibit 19.
Yes, sir.
Just let me know if you recognize that.
Yes, sir. This is going to be the recording of I'm sorry, the Cobb County Police Officer, Jeffrey Williams.
Okay, and based on looking at State's Exhibit 19, have you had an opportunity to review what's on State's Exhibit 19?
Yes, sir.
And is State's Exhibit 19 a fair and accurate copy of the body cam footage you received of the defendant and Officer Williams from the cab speaking?
Yes, sir.
Your Honor, this time the state would tender with remark to State's Exhibit 19 to evidence.
No objection.
19 is admitted, so 17 were okay, because we had 2 other media, and one of them is the phone calls between Detective Thorpe and Ms. Brownmore, and then the other digital media is her statement once in custody at police headquarters.
Yes, 17 is the phone calls, 18 is the statement of the defendant.
So I think 18 is, we may have two 18s because 18 is also the picture of the knife on the ground.
So we will make,
And that was already admitted, so maybe today's 18, we could give a different number?
yes, I apologize, 21.
21, okay. Why don't you renumber just that one?
And what happened with that?
Judge, sorry, I think we already have a 21. You already have a 21 also.
Let's just say 30.
Okay, 30 it is. So let me find that. 30 is the post-arrest interview.
Yes.
Okay,
Now, Detective Thorpe, Ms. Gordon asked you about any evidence that you had found contrary to what Ms. Brown Moore had said. Do you remember that question?
Yes, sir.
Isn't it true that Ms. Brown Moore never actually told you that she was defending herself on August 29th of 2020?
She never gave that statement, sir.
And she never reported to you that she was in any danger, correct?
Objection, Your Honor, this is leading.
Did she ever report to you that she was in any danger on August 29th of 2020?
No, sir.
Did she report to you that she had been assaulted in any way?
No, sir.
Did she report to you that she at all was in fear for her life or her safety on August 29th of 2020?
No, sir.
And did you give her, did you ask her on at least 3 separate occasions if she knew anything about what happened on that night?
Yes, I did.
And did she ever provide you any information about what happened on August 29th of 2020?
No, she didn't, sir.
So would you agree, or is it true that Ms. Brown Moore never provided you any evidence contrary to your investigation?
Correct.
Nothing further, Judge.
Ms. Gordon, anything else for Detective Thorpe?
Very quickly, Detective Thorpe, you never had the opportunity over the course of your investigation to look inside Ms. Brown Moore's vehicle, correct?
Correct.
And so you don't know if there were any casings inside her vehicle.
Correct.
That's all.
I have one very quick question. Is that
Okay.
because Ms. Brown Moore didn't turn the vehicle over to you or any other law enforcement officer after she alleges this occurred on August 29th, 2020?
Correct, sir.
In fact, she disposed of it.
Correct, sir.
Nothing further, Judge.
Okay. Thank you, Detective Thorpe, for your time.
Thank you, Your Honor.
You can leave all the exhibits right there and we'll get them in a minute.
Yes, sir. Thank you, Your Honor.
You bet. Mr. Abate, anything else for the state?
No, Your Honor.
Any rebuttal evidence, Ms. Gordon?
No, Your Honor.
Okay, the evidence is closed. Do you want to make any argument or rely on the record that's been made? How do you want to do that? And we'll talk about bond that you put on the agenda. I just wanted to hear the rest of your evidence and then the state's evidence before we revisited the question of bond.
I would like to argue, Judge. I would allow Mr. Abate to go first.
Okay,
And I would ask for a 5-minute bathroom break before we do so.
why don't we start up at, that clock's a little off, but that's the one we go by because the numbers are big. So why don't we start up at 2:35? And we'll hear from Mr. Abate and you about what I ought to do with the immunity motion. And then we can talk a little bit about bond. Okay,
Thank you, Judge.
thanks. Before you start your break, get me that stuff.
I'm not going to let it go on. Let's submit on the evidence.
Okay, thank you.
I'm sorry. We're done together. We'll let you come out.
What's the
Where?
best?
Where you? Where you? Undergrad? Are you an undergrad or law school? Okay, what year? Okay. I like the first year because it's all more. That's where you have to start thinking for yourself. So I like that. You from around here? Okay. So good, where'd you go to undergrad? Okay. GA is a fun town. Athens is a fun town. I had way too much fun in my 7 years. I tried to make it more, but my parents wouldn't let me. So Lacey, how's it that you and I have been at court all day?
What'd you say?
How are we doing? You've been at court all day.
Oh my God, I know, every time.
What do they hope they can find? I guess it doesn't help. I guess I can take. I don't know you, so I haven't tried not to, but last time you did not file. You looked like a normal birthday, so I beat up the door. I almost never say, but I was certain that. Because I made that mistake. One person I didn't make it to was Wendy Lewis. I suspected, but I was like, I'm not saying. Because she would have beat me.
Oh my God, for sure, for sure.
Yeah, you know, I'm not gonna blare again.
We're not finding out.
That's exciting. I think that's cool. My brother did that with their first kid.
Yeah.
So they liked it.
It's funny, people like to guess. They're like, oh, well, it's high or low or wide or whatever.
I just know it's there. But I hesitated. I almost earlier I was like, nah, but then I was third when you gave back.
Yeah. Yeah, I can't really hide it anymore.
When do you do?
November 15th.
Okay. You got a little bit of time. I'm November 18th. November 18th.
Oh.
So you'll have
all
a
right.
Scorpio.
Scorpio?
Yes. Oh.
It's so hot. Is it just me?
It's been hot in the past. Yeah, last week it was that
What was I gonna say to you? What's YouTube saying?
not paying attention.
No, it's fine. I knew what the answer was, and this is pregnancy brain for fucking real. This is me just like forgetting shit that I know in my head. It's a prior consistent statement.
This is what I was doing. After this, about this right here is happening, and it's what the whole went out. So I'm coming in earlier.
You better not fucking come in here with a presentment. Hmm? Yeah.
Broadcasting. So I was the same frequency as the. Just so generic.
This is ridiculous. Wait, there's no way, right?
I mean, we would know that. If he's back there getting a fucking phone call right now, I'm not gonna lose my shit. Do you see any actual?
Okay, this is what, where is she finding that at?
What is, I can't even see that.
Oh,
Yeah.
hold on. Let me see.
It wouldn't be in Odyssey yet. There's no way.
Again, it's like, could get it. But do you guys have?
Yeah, you're right. There's no way. Yeah. That's not really what she said.
But no.
I mean, the news is saying it's moving faster than anticipated.
I was waiting until this was
Adam,
Yes, sir.
did I hear you say you're not gonna argue?
Yeah, I'm gonna make 3 points. Like, very, just that's it.
Okay.
I don't like a whole lot to say.
You could just plead a false statement. I'm telling you, this is easy. Huh? Answer this question, yes. Okay. Thank you. I got like 9 pages of argument. Don't worry. Can I have the candy? Can I have the- I don't know. Just to be safe. All the stuff about you not being honest with him, we already covered it. It sounds bad when he's up there saying it now. Hold on. Okay.
Bye. Bye.
Board will now come to order. Remain seated, please.
Captain Bonner, you'll come through that door. Come on up, and we're gonna go into the jury room. We'll get started.
That's the part I can't figure out. I guess.
All right. So, Ms. Gordon, as we were starting the break, Mr. Abate said he's just going to rest on the record. I'll let him confirm that on the record, and then you can share with me your argument about why immunity should be granted. Mr. Abate, is that correct? Or during the break, did you have a flash inspiration of things you want to say?
No, that's correct, Judge. I'm gonna rest and submit on the evidence.
Okay. Ms. Gordon.
Judge, my husband and my family will tell you that I'm nothing if not thorough. And so I usually start off arguments like this outlining the law first. I'm going to
Okay.
trust that this court knows the law very well as it relates to immunity and self-defense, just the basics. So I'm going to skip by that.
Okay,
I'm going to start with some case law and then talk more about the evidence that you heard over the course of the hearing. And I have the case law here. To give copies support. May I approach?
sure.
Just in case you need a copy.
Thank you.
The first case that I'll talk about, Judge, is Bunn v. State, 284 Georgia 410. It's a 2008 case. This case clarifies the standard that the defense obviously bears the burden of proof in an immunity motion, and the standard of proof is a preponderance that the defendant acted in self-defense and is immune from prosecution. So that standard, obviously the court knows, means that the superior weight of evidence upon the issues, while not enough to free the mind wholly from reasonable doubt, is sufficient to incline a reasonable and impartial mind to one side of the issue rather than the other. Nothing in this standard requires the elimination of all fact disputes as a matter of law. Rather, quote, the standard requires only that the finder of fact be inclined by the evidence toward one side or the other. So what this means, Judge, is that for the court to say, and this is something that I think we as the defense bar hear a lot when it comes to immunity motions, is the court saying this is a question for the jury. And to deny the motion based on that would be, that would essentially mean that this court is either completely even on where the evidence lies, or that the court believes that this was not self-defense more than the court believes that it was. Believing that there is some evidence against self-defense such that the case could be determined factually by a jury, I think would be skirting what the actual standard in the law is.
But I hear you, and I know judges often say, I'm gonna let the jury sort this out. But if a judge felt like, gosh, I'm actually leaning in the direction of this being a self-defense case, you've met your burden.
Correct.
The reality is you get a self-defense charge if there is even slight evidence that your client acted in self-defense. And there's slight evidence at a minimum because your client has already said under oath, I acted in self-defense. And sounds like her sister would testify to that as well. So it's possible a judge would say the jury will need to work through this. You're not precluded from arguing self-defense at trial, but you haven't met your burden of preponderance.
Sure. What I'm wanting to really point out, though, Judge, is just that just what that standard is, the preponderance standard. That if the court believes that this was self-defense, even a little bit more than that it wasn't self-defense, then we have met that burden.
Right.
So we're not at a charging conference. We're not talking about a jury charge. We're talking about the standard here at the immunity hearing.
Yep.
I would also point out to the court, this is a trial court ruling that is appealable by the state. So if this court is concerned about getting it wrong, this is reviewable. The Court of Appeals will remand if so. The next case I want to talk about, Judge, is State v. Green. That's 289 Georgia 802. It's a 2011 case. And in that case, the trial court granted Green's immunity motion and the state did appeal. Jeffrey Walden was the victim in that case. Green and Walden had a physical struggle, and Green, the defendant, punctured Walden's femoral artery, which ended up killing him. He was charged with malice murder, felony murder, ag assault, and possession of a knife during the commission of a felony. During that physical altercation, Walden had headbutted Green in the mouth, but did not possess any weapons at all. And the court held in that case that 16321 does not require that a person use actual force to support a claim for justification. A mere threat of force is all that is required when one reasonably believes that he must defend himself against another's imminent use of unlawful force. The court went on, in this regard, a person is justified in going beyond merely threatening to use force and actually using force which is intended or likely to cause death or great bodily harm if he reasonably believes that such force is necessary to prevent death or great bodily injury to himself. The court goes on to state the record reveals that Walden was totally irrational, that Green did not know what Walden was going to do, and that Green held onto the knife for protection and to scare Walden. The evidence supports the conclusion that Green reasonably believed that he needed to defend himself from a violent attack from Walden that could have caused him great bodily injury. Thus, Green would have been justified in using deadly force against Walden to protect himself. So in Destiny's case, the threat that she was facing, based on her testimony, was well above and well beyond what Green faced from Walden in that case, in that factual scenario. Walden had no weapons at all. All he did was a headbutt toward Green. Destiny, according to her testimony, had been choked, had been pushed backward into her car, had been threatened with words that showed an intent to sexually assault her. Mr. Hudnall had moved his hand up her leg in an attempt to assault her, and he had grabbed and tried to take her knife from her when she tried to protect herself with it. He had fully physically overpowered her. The Green court specifically talks about Walden being irrational and Green not knowing what Walden was going to do next. And Destiny was being physically overpowered by a man who she had known for no more than 30 minutes, who was attempting to gain control of both her body physically and the weapon, the knife that she had prior to grabbing for that gun. So she was absolutely reasonable in her fear of death or great bodily injury, even more so than the defendant in the Green case. Smith v. State Judge is 215 Georgia 51. That's a 1959 case. In that case, Smith, the defendant, killed her son-in-law after he attacked her with a knife and a pair of scissors. In this court, at trial, the court charged the jury on justifiable homicide. And in doing so, in that case, the court referred in its charge to felonious assault and defined that term for the jury. But it was defined by the court as an assault with intent to kill and did not otherwise define the word felony for the jury. So the court excluded in that case from its definition any other grade of felony. The Supreme Court deemed that error and said justifiable homicide may exist under our law when a person kills another for reasons other than to save his own life. The court goes on to say where the circumstances are sufficient to excite the fears of a reasonable man that a felony is about to be committed on his person, it is justifiable homicide for him to kill another who manifestly intends or endeavors by violence or surprise to commit a felony upon him. And this is true whatever the grade of the felony may be. So our argument today, Judge, is that Destiny's life was absolutely in danger that day. And also, based on her testimony, the decedent committed an aggravated assault against her, which is a felony, attempted a rape against her or a sexual assault against her, which is a felony, committed a false imprisonment against her, which is a felony. So not only was she in reasonable fear of death or great bodily injury, she was also in reasonable fear of being the victim of and had been the victim of multiple felonies before she used force herself. The last case I want to talk about before I talk a little bit more about Destiny's testimony is State v. Jennings. That's 337 Georgia Appeals 164. That's a 2016 case. This case was about a fight between three men. Jennings allegedly owed money to Finch. So Finch and Robinson went and found Jennings, picked him up, roughed him up, tried to get money from him. While Robinson was on top of Jennings, beating him up, Jennings was able to get his gun from his pocket and shot Robinson, and then also shot Finch while he was running into a nearby apartment. During the immunity.
While Jennings was running into a nearby apartment, Finch is running away from the situation and Jennings shoots Finch.
Yes.
Okay.
During the immunity hearing, and just to be clear, Judge, the ruling in this case, this is State v. Jennings. I think the ruling is as to Jennings, not Finch.
Oh, Jennings is one of the two.
It's 2 against 1.
Right.
So we've got Jennings is the defendant. We've got Jennings on one side, Finch and Robinson on the other side.
Right. And it as to Robinson and not Finch.
I believe.
Good. Okay.
During the immunity hearing, the court heard contradicting testimony from Jennings, the defendant, Finch, one of the victims, and Finch's girlfriend about how the incident had gone down. Despite the contradictory testimony, the court found that Jennings did carry his burden of proving by a preponderance of the evidence that he was reasonable in his belief that deadly force was necessary in regard to Robinson, who was on top of Jennings and actively assaulting him at the time he fired the shots. The case came down to the credibility of the witnesses. And even though there was contradictory testimony from others, the court believed Jennings' account of events and was affirmed in finding that he was immune from prosecution. So obviously, Judge, I think there's going to be a question for the court today about veracity of witness testimony, and I'm going to talk a little bit more about that. But this case shows that if the court believes Destiny's account of events, such that it did Jennings' account of events in that case, that would be enough. And the court was affirmed in finding immunity and believing that testimony over other testimony. So the biggest question for the court obviously is, why should this court believe Destiny? If Your Honor believes Destiny's testimony today, which is really the only direct evidence of what actually happened on that night or that early morning, I don't think that there could be any argument at all as to whether or not she was reasonably acting in self-defense. Of course she was, based on what I've already talked about a little bit. So the question is her veracity, right? And I want to go back through a little bit just what she testified to. So the first question that we're asking when we're looking at self-defense and immunity is whether she believes that she was in danger of death or great bodily injury, and whether that belief was reasonable. She was, based on her testimony, she was a woman by herself in the early morning hours in the dark. She was physically attacked by a man she had just met. There was no one around to help her. She was on a street that was mostly empty at the time. Before he physically touched her, he parked his car alongside hers in such a way that she was blocked in and could not leave. If you'll recall, her testimony was that she was parked against the curb. He parked basically right next to her car in a sort of double park situation. There were cars in front of her and behind her. That's where the false imprisonment starts. He then put his hands around her neck and choked her, which is aggravated assault. He pushed her back into her car so that she could not escape his grip. Again, false imprisonment here. His words, according to Destiny, "You're going to give me that pussy," indicated clearly what his intent was, which was to sexually assault her. His hands moved up her leg toward her vagina, while he also had a hand on her throat. When she grabbed a knife to try to protect herself, he attempted to get that knife from her hands. The only conclusion to draw from this is that he was going to either use that knife to physically harm her, or he was going to throw that knife away out of her reach so that he could continue to attempt his sexual assault that he had already begun at that point. Only when he could not get control, only when she, Destiny, could not get control of her knife, when he still had a grip on it, trying to get it from her, it was only then that she reached for and then fired her gun. Not only was Destiny herself in that moment completely reasonable in her belief that she was in imminent danger of being raped or killed by this man, but any reasonable woman in her position would have felt the same way. The next question we're looking at under the law is whether force was necessary to prevent death or great bodily injury. Destiny was in reasonable fear that she would be raped or killed by this man based entirely on his words and his actions. He blocked her in, he physically blocked her exit or her escape. He physically and sexually assaulted her, he verbally assaulted her, he would not let her go. The next question would be, was Destiny trying to prevent the commission of a forcible felony? And I've talked about this already. He committed an aggravated assault, false imprisonment, attempted rape or sexual assault, and terroristic threats as well with the, you're gonna give me that, that he said to her. Did Destiny initially provoke the use of force? No, she declined his invitation to go to his hotel room, and then he physically attacked her. She only responded to his attack. Was she committing or attempting to commit or fleeing from the commission of a felony? No, there's no evidence of that. You heard me ask questions about whether anything was stolen from Mr. Hudnall, and that was based on some questions or some statements that Mr. Abate had made back at our initial bond hearing in this case, sort of surmising that this may have been an attempted armed robbery on Destiny's part. None of that evidence was presented today. There is no evidence of that. And in fact, there was a lot of cash, jewelry, watch, all of that on his person and in his car in plain view. And you saw the pictures of that. So there's certainly no evidence that Destiny was committing or attempting to commit or fleeing from the commission of a felony when this occurred. And then was she the aggressor or was she engaged in combat by agreement? Certainly not. He was the aggressor. In terms of her veracity, Judge, why should the court believe her testimony? Obviously, the questions that Mr. Abate asked his witness and some of the cross-examination questions that he asked my witnesses were intended to lead this court to believe that Destiny was not truthful, is not truthful about what happened in August of 2020. So why should this court believe her? First, her account is very detailed. She was able to walk this court through every detail of what happened that night, including timeframes, locations, words exchanged, clothing worn. Mr. Abate in his cross-examination of Destiny certainly tried to trip her up by asking her some questions about details of her life, other happenings around that time. But it's totally understandable, I think, that Destiny would remember details of this incident, which has been burned in her brain, which was traumatic for her, which was very unlike anything else that had happened in her life ever, certainly around that time, and that she might not remember other little details about what had been, this is 3 years ago. I can barely remember what I had for dinner last night. Second reason why the court should believe her testimony, her account was emotional. The court saw Destiny on the witness stand, and her demeanor on the witness stand was consistent with someone who has been a victim of an attempted sexual assault and someone who has lived with the trauma of what happened that night for the past 3 years. Third reason, her personal account can be corroborated and is corroborated by the state's evidence. So Destiny described Mr. Hudnall as wearing an all-white outfit. He was wearing an all-white outfit, as you heard from the detective. Destiny told you about the knife that she had and that he tried to get from her. That knife was found on scene. Destiny told you that the decedent asked her to come back to his hotel room with him, and it was confirmed by the evidence that he was in fact staying at the Ritz-Carlton Hotel that night. She told you that she saw Mr. Hudnall drive off in his car, crash it. That's exactly what happened based on the evidence that the state has. And she told you that she did not have any intention, nor did she make any attempt to steal anything from him. And again, that's corroborated by all of the money and valuable belongings that were found on him. In regard to the shell casings, and you heard from the detective that the one piece of evidence the state has, and the only one that contradicts Destiny's account of this being self-defense, is these shell casings that we talked about. I want to remind the court that Destiny's testimony was not, in fact, that she was still lying down in the car when she fired the shots. Her testimony was that initially she had been standing in between the two cars, speaking with this guy. Their car doors had been open. The attack on her began and she was pushed back into her car. And that's when she landed on her back and was struggling with his body on top of hers. At some point during that struggle, she testified that she hit him. I think she said she punched him or hit him in the face, causing him to back up. And that allowed her to shut her car door. And at that point, she was sitting up in her car in the driver's seat. he was still trying to get at her. He was still, I think her testimony was that his arms and part of his upper body were still leaning into her car in her window, trying to get that knife from her, but she was no longer on her back. She was sitting up. So it makes complete sense that at least some shell casings, if she fired, like I demonstrated for the witness, out that window at him, that those shell casings would ricochet off of the steering wheel, the dash, the windshield, and some of them would end up out in the street. We don't know. We haven't been presented with any evidence of exactly how many shots were fired. And so we don't know exactly how many casings there were. And we don't know if there were any casings in Destiny's car. Excuse me. Destiny's account of that night has been consistent. Her sister Jessica told you that she called her that morning right after this happened, that she was shaken, that she was scared, that her voice was high pitched, that she was frantic, that she had to tell her to calm down, slow down, and that she told Jessica that this man had attacked her, that he had choked her, and that he had tried to rape her. She told Jeffrey Williams, you heard the testimony of the detective, that he listened to that body cam recording, and she told Jeffrey Williams that this was self-defense, that she was on her back, that she was fighting this guy off, that he was on top of her, choking her. And that's exactly the same thing she told this court. So her testimony was detailed, it was emotional, it is corroborated by the evidence the state has, and it has been consistent throughout. And we've also addressed the reasons, and obviously, you know, what's the reason not to believe Destiny? Well, you heard that she wasn't truthful with the detective. We addressed that on direct. I knew, you know, obviously I knew the evidence in this case. I knew that she wasn't truthful with the detective. Destiny knows that she wasn't truthful with the detective. She was terrified. She had just gotten her life back on track when she was brought in, when she was arrested, when she was questioned. She had gotten an apartment, gotten a job, gotten partial custody of her child back. And she was really scared to mess all of that up. She told the court during her testimony that she realized part of the way through that interview, she didn't say it, and the court obviously will listen to and watch the interviews. She didn't say it, but she realized part of the way through that conversation that she probably shouldn't have been having that conversation without a lawyer present. Destiny, like many of my clients, doesn't know the law, doesn't know it nearly as well as you and I do. And so she didn't vocalize that, but she knew it. And that's why she wasn't truthful with the officer. And to be candid with the court, Destiny's fear was very real and very rational and very reasonable, because look where she is now, right? Everything that she was afraid would happen has happened. She's been in custody for months and months. She's been separated from her family and, most importantly, her child. She has no bond. She's being charged with murder. She's facing a potential life sentence. So everything that she was afraid of, she was very reasonable in that fear. Again, she didn't know the law. She doesn't know the law, where burdens lie when it comes to criminal cases. She knew that she alone could tell this story, and thought that because she didn't have any proof, that she couldn't prove that she had acted in self-defense, that nobody would believe her and that she would lose everything. And she's in the middle of, or at least on the brink of that very scary reality. Judge, I think based on everything that's been presented, Destiny has certainly met her burden today. The state has provided no evidence to actually contradict Destiny's account of events that night. Her account of events makes sense. It fits with the facts and the evidence that the state does have and the state has presented. Her account has been consistent, and Destiny acted as any reasonable person, and specifically any reasonable woman, would have that morning in August of 2020. She acted clearly in self-defense. And based on all of that, I would ask that the court grant immunity. I think that Destiny is entitled to immunity in this case.
Okay. While you're standing there, why don't you talk to me about bond?
I would love to.
If there are things you want to add. I know primarily the thing that's changed from last time we talked about it is that Ms. Brown-Moore's been in custody longer. I don't know if there have been other changes in her circumstances or this case. Other than I know a whole lot more about what some of the evidence will be.
Those are the main things that have changed, Judge. She has been in custody longer. I don't have the exact date with me that we had the last bond hearing, but it's been, I think it was April. So she's been in custody several months longer than last time we were here. That's several months more that she's been separated from her child, several months more that she's been out of work, several months more that are going to make it a lot more difficult for her to get back on her feet. In those several months, I'm sure the court knows that we have experienced more death in the Fulton County Jail, including a female inmate just a few weeks ago. So I would just stress again to the court that the Fulton County Jail system is an incredibly unsafe place for a human being to reside. I won't repeat everything that I said in our last bond hearing. Destiny has no history, no violent history. She is certainly not a danger to this community. Of course, she'll abide by a no contact order. She doesn't wish to or need to have any contact with the victim's family in this case. If she is granted bond, Judge, she will go back to being a mother, trying to get her life back on the track that it was at the time of her arrest, where she had made so much progress. The court has seen that she has consistent and solid family support. Two of her sisters are here present in the courtroom today. The only two in here who are not media. They were here last time as well. You've seen on Zoom her other sister, Jessica, who's in New York, but even prior to that, at our last bond hearing, she had several other family members present as well in support of her. So she's got a ton of support. She's not a risk of flight. She's not a risk of committing any future felonies. She is very, very well aware of the gravity of this case and knows that a violation of a bond order in this court would result in her being back in custody and would put her in a worse position than she's already currently in. So based on that, Judge, based on, and frankly, based on the evidence that you've heard during this, this extended hearing, I would ask that the court grant a reasonable bond, considering the time that she's been in custody, understanding this is obviously a very, very serious charge and a very, very serious case. I do think that Destiny is an excellent candidate for bond. I don't think she will violate a single condition of this court's order.
Okay, thank you. Mr. Abate, anything you want to say on bond?
Your Honor, I would just reiterate the things that I had brought to the court's attention last time. Most importantly, that the defendant is a risk if released from the custody of the Fulton County Sheriff's Department of further obstructing the administration of justice. That has been her entire MO, for lack of better words, since this incident occurred. Destiny had, or the defendant, Ms. Brown-Moore, had more than 2 years to confide in law enforcement officers, family, friends who could help her come forward. She didn't do that. Instead, she continued to violate the law, which she admitted to during the hearing, continuing to do cocaine and other illicit drugs that she was doing that night, and she admitted to continuing to do after this incident occurred. I'd also bring to the court's attention, counsel referenced that if released on bond, that she would have a job or be working. The court heard testimony extensively about Ms. Brown-Moore's work history, and I would submit to the court that there isn't much of one of actual work, just from the testimony from Ms. Brown-Moore. I'm not saying that she isn't capable or doesn't have the ability to work. I would just bring to the court's attention that she hadn't been working, and the things and places that she said that she had worked, there was no true volition to, I guess, the things that she said she had alleged to have done when asked about the specifics and details of where she worked, certification, things of that nature, which would be required for all of the jobs, majority of the jobs that she told the court about. Most importantly, Your Honor, I would submit to the court that there's the evidence is such that the state's theory of the case, as defense counsel referenced, not only during her argument for her immunity motion, but also during the bond hearing, that the state's theory and contentions about the evidence are nothing of the sort. But I would bring to the court's attention, based on what you heard, Ms. Brown Moore indicated that the entire struggle was inside of that vehicle, including the struggle with the knife, which she said that she never lost possession of. The evidence is clear that where the car was found is not where this alleged struggle or interaction between the defendant and the victim occurred. The knife was found behind the back tire of where the vehicle laid rest after being shot and hitting the building in which Mr. Hundle never recovered from his gunshot wounds. I'd bring to the court's attention that Mr. Hundle was shot 3 times, one of them being in the back, consistent with him being seated in the vehicle and entering his back as he ducked or tried to get away as he was driving. Very contrary to the evidence that was presented during the immunity motion and the bond motion as it relates to Ms. Brown Moore. I'd also bring to the court's attention that the Fulton County Jail is a place where the defendant can remain sober, unlike how she was living prior to being arrested. I understand that she does have family support, but family support can only take you so far as it relates to your own decisions. And I think this case is a clear example that regardless and despite all the family support that Ms. Brown Moore had, she was involved in drugs, she was involved in lying, she was involved in cover-ups, and she was involved in the ultimate death of Hakeem Hundle in this case, Your Honor. And I would respectfully request you deny defense counsel's motion for all of those reasons.
So Ms. Brown Moore, what I'm going to do is take the immunity motion under advisement. I've received a whole lot of information, both back at the end of June when you testified, and then this afternoon from your sister and the detective, and a whole lot of law from your lawyer. And I'm going to rule on the immunity motion. If I grant the immunity motion, you don't need to worry about bond. That will be the way I address your bond. If I deny the immunity motion, then my goal will be to get this case before a jury right away. I don't think there's any more discovery that needs to go back and forth. This is what has kept the case from getting to a jury, the immunity motion needing to have the full hearing and me ruling on it. So I suspect that's what I'll do. I don't think I would deny the immunity motion, but give you a bond. I would likely deny it and say, let's get in here for a trial. And as I said, if I grant the immunity motion, then even if there is an appeal, I'd set a bond for you that ideally you'd be able to make, and we need to talk about how that would be structured, but we'd certainly revisit that. So that's my plan and the work that I now need to do after your lawyer has done a whole bunch of work on your behalf and Mr. Abate has done work on behalf of the state. Ms. Gordon, am I correct that you're good to go with discovery, or are there any pieces missing that you're aware of?
I don't believe there's anything outstanding at this point, Judge.
Mr. Abate, is there any, the thing that always comes up just before trial starts is ballistics. I know there were shell casings found. There's no gun that was recovered. So the only ballistics would be all these shell casings came from the same gun. It's a 9mm, and maybe the tool markings are consistent with a Glock. But has that happened, or can it happen quickly?
It can happen quickly, Your Honor. I would say to the court, which I don't typically say, in this case, the ballistics are much less important in the sense that we know who shot the firearm. There's, based on the testimony that we received from the defendant during this immunity motion, that's not in question at all. So I'm going to have them tested by a private firearms examiner to expedite the process. But no, Your Honor, that won't hold it up. And just for the record, I forgot to mention to the court and to counsel, Mr. Hundle's family, his father, Mr. Brown, no relation to the defendant, and his mother and other family members are not only on the Zoom, but also watching the live stream on YouTube. And they wanted to make sure they stressed to the court that their arguments in their pleas to the court that they made previously during the last bond hearing where they traveled from Mississippi, that they stood and they still stand, and they respect the request, Your Honor, to not grant bond.
Okay. Ms. Gordon, anything else you wanted to cover while we were all together today? We've addressed immunity. I need to rule on it, enter an order. We've talked about bond, told you how I'm planning on handling that. Anything else?
Just so I'm clear, Judge, is the court denying bond today?
No, I'm deferring my ruling, and we'll do that concomitantly with my order on the immunity motion. Anything else?
No, Judge.
Okay, Mr. Abate?
Just one issue. During the last hearing or at the very beginning, counsel had indicated to both the state as well as to Your Honor that there was no issue as it pertained to the voluntariness of the statement made by Ms. Brown Moore. And I was wondering if the court wanted me to draft an order saying that Your Honor had found it to be voluntary and admissible because it was moot, or you wanted to draft it. I just wanted to bring that to your attention as one of the issues.
So I've got the statement now, so I can review it. I haven't seen any motion from the defense saying we want to exclude it because it was unconstitutionally obtained. Do you agree? I'll watch it, but that from your review, Ms. Gordon, the exchange that Detective Thorpe had with Ms. Brown Moore appears to you to have met the basic requirements of getting a statement from someone who is in custody.
Yes, Judge, I haven't filed a particularized Jackson gun.
Okay, but, and I want to get an order in place that makes plain both sides can use it if it's otherwise admissible. Are you challenging its admissibility? If you want to think about that, that's fine. I don't think there is before me a challenge from the defense as to the admissibility of Ms. Brown Moore's statement to Detective Thorpe on constitutional grounds.
There's not before the court right now. I probably will not file one. Obviously, we do have to have a finding as to voluntariness. But I'll talk with Mr. Abate about it, and if he wants to draft an order, I will take a look at it.
I'll take care of it, but I didn't want to enter an order after I watched the statement if without hearing from you if you had concerns. If you've watched it and it clears however high the bar is in your mind, or as the law has said it, then there's nothing for you to brief. I just didn't want to enter the order and then you come behind that saying, wait a minute, when did I get a chance to argue it? That was the only reason why I was asking you. But it sounds like you're comfortable if I review it and find that there was a knowing and voluntary waiver of rights and no promises or improper inducements or anything like that, that I can enter an order to that effect, and that will memorialize what needs to be for whatever purposes down the road, and you won't have an issue with that.
Correct.
Okay.
And I apologize. The only reason I brought it up is because at the beginning of the hearing last time in June, it was my recollection, and I could be very wrong, that counsel had stated that there was no constitutional or any other admissibilities as it relates to the statement. I could be getting it confused. There's a lot of cases that we all are working and swirling through. And just for the record, I wanted to apologize to the victim's father. It's not Brown, it's Mr. Michael Moore, similar to Miss Brown Moore, but I got the last.
Got the wrong half.
So I wanted to make sure that I clarified that in respect to him.
Okay, got it. That's it. So Ms. Brown Moore, I will see you again. Either, well, it would be if we're going to have a trial. I don't need to see you if I grant the motion for immunity. And if that gets appealed, that goes on up to Supreme Court, Court of Appeals, wherever it would go, Supreme Court. And you don't show up for those kinds of things. Although if you're on bond, you can watch the oral argument if they have it. So that's when I will see you next. Do you have any questions about process?
So if I'm not getting the bond today, then if you don't grant me immunity, then I will be receiving the bond?
So I'm sorry if I wasn't clear. If I grant you immunity, then I'm saying that the state can't prosecute you for, I have to look at the indictment and make sure there's not something that would survive a grant of immunity. I don't think there is. I think that basically all the charges relate to the alleged crime of violence that you committed against the victim. And if I say that if I find that your lawyer has shown by a preponderance that your actions were justified, then I'm effectively dismissing the state's case. If I dismiss the state's case, you shouldn't be held on any charges because there aren't any charges. And so I'd set a bond, and then your lawyer could say, actually, you can't set a bond. There's no case left, but it makes sense to set that bond. The state would likely appeal, and that takes a while for it to be resolved. And I would want to make clear that my view is that you should be at liberty under certain conditions while that appeal is being heard. If I deny the motion, then I probably am not going to set a bond based on what I've heard throughout the course of the immunity hearing and what I recall hearing from the first bond motion. And that's why I was saying, if I deny the immunity motion, my goal is to get you a trial as soon as possible. Because then if a jury says not guilty for whatever reason, you don't need to worry about bond. And if a jury says guilty, then you're going to need to work through the consequences of that. But I'll know I'll be able to find you for that because you will have been brought to court for the trial and you'll be here until the trial has concluded. Okay? All right. Thank you, everyone.
Thank you, Judge.
Ms. Smith? She's outside. You can give that to Ms. Smith.
Judge, can I approach you later?
Yes. There's a number. No. Hold on one second. Right. Well, and right. And we allegedly have a whole protocol we're going through to, yeah, no such number. That's funny. Circulating. Okay. That's the media for you.
It's final, please.
What's all this?
Can you call that?
Oh, okay. Yeah.
I just came in.
Okay. Ms. Nelson, we're done, so I can end the Zoom. Is that correct?
Unless you need takedown from Karen for some other matter or anything like that.
Nope. Thanks, Ms. Rivers. I will see you guys virtually or in person tomorrow.